Hello, everyone, and a very welcome to all of you joining us today for this webinar on the procedural right of migrant and refugee children in legal proceedings. I'm happy to see that so many of you are still joining. So to stay on time, I suggest we start and people will join. So before we begin, just a quick reminder, this webinar is being recorded and the recording may be made publicly available on YouTube. So if you prefer not to appear in the video, please turn off your camera, but we are so happy to see faces. So my name is Laura Duchamp. I'm a legal researcher at the International Commission of Jurists. The ICJ is a global human rights organization working to ensure that international human rights law is effectively implemented in national laws and practices. So the ICJ has been working and actively promoting the rights of the child for many years. And today's webinar is an EU-funded project called A Voice, Be Seen, Be Heard, Empowering Child Voices in Legal Proceedings. This is a collaborative project with 4 national partners, and the work aims at promoting the effective realization of children's right to be heard and to participate in judicial and legal proceeding in line with both the UN Convention on the Right of the Child and the EU Strategy on the Right of the Child. And today's session focuses specifically on international and EU frameworks that safeguard the procedural rights of migrant and refugee children, particularly regarding their participation in asylum and migration-related proceedings. So this is actually the second webinar of the series of 3. If you missed the first one, which focused on the role of the representative and on the right of the child to be heard, you can find it on YouTube. And now we are very pleased to have 2 distinguished speakers with us today. After their presentation, we'll have around half an hour for discussion, but please feel free to use the chat for the session if you have anything to raise, so we can discuss this after. So our first speaker is Mikiko Otani, a commissioner at the ICJ. Mikiko is an international human rights lawyer based in Japan, specializing in women's and children's rights. She is also a former member and chair of the UN Committee on the Right of the Child, and currently serves as president of the Child Rights Connect. So we are honored to have you with us, Mikiko. So I give you the floor now already.
Thank you very much. Being mindful of the time, I will start my presentation. So I will share the slide. Okay. Can you see the slide? Okay.
Yes.
So thank you very much. So this is the outline of my presentation. Actually, I have around 60 pages of slides, so I will just go straight to the contents. So firstly, I'd like to start with talking a little bit about the scope of the topic. Though the topic is procedural safeguards in asylum and migration procedures, we need to understand who are the children we are talking about. Of course, migrant, asylum seeking, and refugee children. However, this is actually a very broad category of the children. Those children may be those who are migrated into your country or on the move and in transition in your country, or born in your country, unaccompanied, separated, and also the accompanied children with the parents. Children of the nationality of your country, foreign country, or stateless children. documented and undocumented children. And some children might be in a particular vulnerabilities. So this is what we should be aware of. And the proceeding concerned, of course, immigration and asylum proceedings. However, in relation to that, very often the children go through other proceedings such as family proceedings, civil proceeding, and if they are suspected or accused as offenders of the criminal law, then they also go through criminal proceeding. Some proceedings are judicial by the courts and some are administrative. The cases issues covered are very broad again. Residential status, asylum status, deportation, of course. However, other very critical issues involved are age determination, guardianship, nationality, removal from the parents, placement into alternative care, sometimes adoption, separation from parents, visitation, and as I said earlier, criminal responsibilities. But also such issues as enrollment in the school comes up, and access to health services, social security, and if their rights are violated, children want to seek remedies in those proceedings. So this is just a list of all rights, maybe not comprehensive, but I highlighted to remind us we are talking about procedural rights of the children. However, those procedural rights of the children affect those rights under the Convention on the Rights of the Child. So this is very important to talk about procedural rights. Now I'm going into the procedural rights and safeguards of children in legal proceedings. Again, I'd like to speak a little bit the wider issue here before going into the procedural rights and safeguards of children, asylum and migration procedures. So these are the concepts which are relevant to our topic. You may be familiar with those concepts: access to justice and effective remedies, child justice, or you may be more familiar with the concept or term juvenile justice, and child-friendly justice or child-sensitive justice. Committee on the Rights of the Child, the monitoring body of the Convention on the Rights of the Child, issues the documents which are called general comments, which provide interpretation of the rights under the Convention or clarify the state obligations and provide guidance to state parties. So general comment number 5 clarified the children has the right to effective remedies. And this is fundamental because otherwise the right is not meaningless. And the access to justice and effective remedy for the children should be child-sensitive and procedures, and also the provision of child-friendly information is very important, and the access to courts with necessary legal and other assistance. In 2013, the High Commissioner for Human Rights issued a report on the access to justice for children. And in this report, access to justice is identified as the ability to obtain a just and timely remedy for violation of rights, and clarified that it applies to civil, administrative, and criminal spheres, and covers all relevant judicial proceedings affecting children, including children alleged as accused or recognized as having infringed the penal law, victims and witnesses or children coming into contact with the justice system for other reasons, such as regarding their care, custody, or protection. So it is the elaboration of the general comment number 5, but it clarified the access to justice for children covers all range of proceedings and such issues as care, custody, and protection. And in the same report, High Commissioner also clarified the relevant other concepts such as juvenile justice, which is actually the procedure or system for the children, child offenders, or the children who are suspected or accused as offending the criminal law. And the child-friendly justice is maybe would be familiar to the participants from the Europe, because this is the concept used in Europe. And here I'd like to highlight the child-friendly justice means respecting the rights of the child, including the rights to due process, and to participate in and to understanding the proceedings, to respect for private and family life, and to integrity and dignity. So why I talked about those three concepts? Because the procedural rights and safeguards of the children in asylum and migration procedures, which comes from actually those areas. Access to justice and effective remedies are mainly in the situation where children's rights are violated and the children want to get remedies. The child justice or juvenile justice is the area child suspects and accused. But as I said earlier, the children in migration situation may be brought to the criminal procedure. So this is also very relevant. And finally, child-friendly justice or sensitive justice is a broad concept, and which encompasses all the procedures where the children are involved. And it requires a child-sensitive procedure, child-friendly information, access to courts, access to legal representation, and this applies to all the cases such as asylum and migration procedures, age determination, care, placement, or age determination. Yeah, so now this is the main component of today's my presentation: international legal framework for the procedural rights and safeguards of children in asylum and migration proceedings. When we use the term international legal framework, actually it covers the universal in another meaning, in the other way, the United Nations legal framework, but as well as the regional framework. However, my presentation is going to be limited only to the international level, the legal framework developed and established at the United Nations. I identify three components which form international legal framework for the procedural rights of the children in migration and asylum procedure. One is the due process rights in general under international human rights law. Second, procedural rights of children, so specifically for children under the Convention on the Rights of the Child. Third, the due process rights of migrants. So here, another special group, migrants and their families under the International Convention on the all migrants and members of their families. So first component is the due process rights in general, and right to equality before courts and fair trial, which is provided in Article 14 of ICCR, applies to all persons, all individuals, regardless of nationality or statelessness, asylum seekers, refugees, and also unaccompanied children or other persons. So this is very important to understand that not only the Convention on the Rights of the Child, but the general international human rights law applies to the children. And ICCPR Article 9 and 10 also provides the procedural rights concerning the right to liberty. When the person is deprived of liberty, what kind of procedural rights are guaranteed. Also, the ICCPR Article 13 provides procedural safeguards of expulsion of aliens. And finally, ICCPR has some specific provisions which provide special protection of children. So now the second component, and this is our focus, is the procedural rights of children under the Convention on the Rights of the Child. First two are sort of elaboration of ICCPR provisions specifically for the children. But the two others highlighted in red color are special procedural rights under the Convention on the Rights of the Child, especially for the children. One is best interest of the child, and the other is right to be heard. Best interest of the child, you may have heard all the time, but today we are talking about the best interest of the child as a procedural rights. So actually, the Article 3, paragraph 1 talks about how what is the obligation of the state parties about best interest of the child. So the courts of law, administrative authorities have to ensure that the best interest of the child are assessed and taken as a primary consideration in all actions. And the Committee on the Rights of the Child, in General Comment number 14, said this right is a substantive right, an interpretative legal principle, and a rule of procedure, and clarified it needs to be explicitly applied through individual procedures as an integral part of any administrative or judicial decision. And this is clarified in the general comment number 22, which I will explain more later. But this best interest of the child should apply entry, residence or return of the child, placement or care of the child, or the detention of expulsion of a parent. Why parent? So, of course, the Article 3 says that all the decisions concerning the children, best interest of the child has to be primary consideration. But why the procedures about the parent? Because if the parent is detained or expelled, it is concerning the children. It has an impact on the children. So this is the very important point for us to understand that the best interest of the child applies not only to the children procedures, but also the procedures concerning their parents. Rights of the child to be heard, again, it is a substantive right, but also a procedural right. And this right of the child to be heard and the best interest of the child hand in hand conform the very important procedural safeguards of the child rights. And also, I think that the right of the child to be heard is a key to treating a child as an individual rights holder. So general comment 12 on the right of the child to be heard has a specific paragraph, how it applies in immigration and asylum proceedings. Also, general comment 12 provided the processes, how the children should be heard and participate. So these are the necessary steps and processes, and all those apply also to the migration and asylum proceedings. So now the third component to form in the national legal framework for the procedural rights of the children in asylum and migration, migration procedures is the due process rights of migrants and migrant families under the International Convention on the Protection of All Migrant Workers and Members of Their Families. I want to highlight the fact that this convention adopted in 1990, however, as of today, only 60 countries ratified. So why it is relevant? even if your country has not ratified this convention, the elements which were highlighted in the convention provide specific attention to the vulnerable situation of migrants and their families. So that is why these elements are very important when we talk about the procedural rights of the migrant children, even if your country is not a state party. So I highlighted some of the important points, such as right to liberty, right to equality before courts and for fair trial, which are also elaboration of the same provision, same rights under the ICCPR. Procedural safeguard of expulsion is also elaborated compared to the ICCPR. Special elements for the migrants and their families are, for example, non-documented migrant situation, family members of the migrants, verification of the identity card, the language issue, interpretation needs, the consular protection, right to equality with nationals of the state, and also the state obligations are very broad. Not only the so-called country of destination, but also the country of transit. So now I come to the jurisprudence of the Committee on the Rights of the Child. When the committee talks about the jurisprudence, generally three types of jurisprudence exist. One is the concluding observations based on the reporting procedures. So these concluding observations include country-specific recommendations. Secondly, general comments. This is the interpretation of the CRC articles or provide guidance to state parties and clarify what state parties need to do to implement specific rights or address certain topics. Third is the decisions of individual communications and reports of inquiry cases under the optional protocol to the CRC on the communications procedure. General comments, I already touched upon a little bit, but I listed here all the relevant general comments. I started talking about the general comment 22 earlier, 22 and 23. However, before that, the committee adopted general comment number 6 in 2005 on treatment of unaccompanied and separated children outside their country of origin. This is still relevant today. However, number 22 and 23 are the most relevant, I would say, for two reasons. One is the scope of the children covered by the general comment is much broader than the general comment number 6. Secondly, these two general comments are actually joint general comments of the Committee on the Rights of the Child and the Committee on the Migrant Workers. So I earlier mentioned the due process rights for the migrants and the migrant families, which are provided under the Convention on the Rights of All Migrant Workers and the members of their families. These elements actually are integrated into those two general comments, 22 and 23, and applies to the all state parties to the Convention on the Rights of the Child, irrespective the state status about the Migrant Workers Convention. So that is why these two general comments are very long documents, but I strongly suggest you should read and become familiar with what the committee said together with the Committee on Migrant Workers. General comment 12 and 14 are also very important because it explains much more in detail on the right of the child to be heard and the best interest of the child. General comment 22 has the section on the best interest of the child. I will not go through because of the time constraint. However, some of the points I'd like to highlight is the best interest of the child requires individual assessment, case by case, and the child by for the individual child. And also, it needs to be applied in all proceedings, as I mentioned earlier, not only about the proceedings concerning the children, but also the proceedings, migration procedures about their children, because the deportations have an impact on the children. So I will skip, but so I highlighted some of the important points, I believe. And yes, I want to highlight one more point. So the one point here is that because the best interest of the child is the procedural safeguard for the children's rights, firstly, children need to be identified as children. So this is the starting point as procedural safeguard for best interest of the child assessment and determination. And child protection has a very important role, and the child participation is required. And so evidentiary considerations on a case-by-case basis. So these are the important elements of the best interest of the assessment and the determination. Right to be heard, again, General Comment 22 provides the specific application of right to be heard in the situation of children in migration context. But I will skip here and go to General Comment number 23, which has the specific section on due process guarantee. But so this slide will be shared with all the participants, so I will just go quickly. And I will summarize all the points later on, so allow me to skip all those slides. One point I want to highlight here. So I earlier mentioned the importance of the recognition of the children or identification of the children as children. But before that, children needs to access to the territory. Again, this is also the starting point as a procedural safeguard. And one important point, so as a due process includes the appeal rights. When the children's rights are not guaranteed, in particular procedural rights, the children should have a right to appeal. Right to liberty, I will skip here. And now I come to the individual communications. And I'd like to introduce some of the decisions of the committee which are relevant to the topic today. So first group is the age determination case. The second group is enrollment of school case. Third is non-refoulement case. And finally, placement case. However, the last case is not about the case of migrant children. However, I think it is very useful for us to understand the committee's interpretation of the the right of the child to be heard. So this is the case of age determination. And actually, these cases were adopted after the committee adopted General Comment 22 and 23. So what the General Comment said was the basis of those decisions of the committee. So you will find that how the general comments is used in the decision of the committee in those cases. And also the age determination case, the committee found in some case, such as this, the violation of the Article 8 of the Convention, the right to identity, because the state party failed to respect the identity of the author and the child by denying that the birth certificate had any probative value without a prior formal assessment of the data. So I highlighted earlier the importance of the ID. And so this is the case of finding violation of Article 5. This is a case, again, about age determination, but this case has some specific element, such as the children are in vulnerable situations. And also the language issue, interpretation issue. So the committee found the violation of best interest of the child, right of the child to be heard, but also the Article 20, the children's right to alternative care, and the 37, because children were remained in the inhuman treatment. So you will see that Article 3, best interest of the child, and rights of the child to be heard under Article 12 are procedural safeguards for other children's rights, such as alternative care and the children's treatment. So this is the case about the child who were denied in enrollment of the school. And again, you will find the Article 3, the best interest of the child is a procedural safeguard for the migrant child's right to education under Article 28. I put one note here. This case didn't find Article 12, the right of the child to be heard, although the child was not individually assessed or heard in the proceeding. So I think that when the best interest of the child is at the issue, the lawyers should also look at the proceedings and check if the child was actually to be heard in the proceedings. And if not, I think the legal counsel, lawyers can also claim the violation of the right of the child to be heard together with the best interest of the child violation. So 2 cases about the non-refoulement, and this is a non-violation, and you will see how the committee used the best interest of the child argument in the non-refoulement case. This is the, again, non-refoulement case, but in this case, the committee examined the best interest of the child and found if the child is deported to China, the child may be at the risk of non-registration in the family registry, which will be the basis for all the access to the services. So the committee found in this case the violation not only the Article 3, best interest of the child, but also the Article 6 and 8. Finally, this is the case. It's a case not of the migrant child. However, I included this case, which might be useful for the migrant children's cases when the children were represented by the guardian, or but the children were adolescents, and children believed that their guardians didn't present their views in the judicial proceedings. So in this case, the committee found failure to have heard the children during the domestic proceedings leading to their placement in institutional care amounts to a violation of Article 12 of the Convention. So this slide introduced one case about the deportation of the author's parents, not the children, but the case was brought claiming that this is a violation of the child rights. And I put the note again, the Human Rights Committee jurisprudence is already established to find violation of the rights of the child under the Article 12, 23 and 24 of the ICCPR in the case of deportation of the child's parents. I think it is very important, as I emphasized again and again earlier, that the best interest of the child and the rights of the child to be heard needs to be guaranteed in the case of the deportation of the child's parents. So this is the third category of jurisprudence, concluding observations, and I introduce one example, which is the most relevant, most recent one, the concluding observation to Romania in 2025. And you will find, so the heading, such as asylum seeking, refugee and migrant children, which includes a lot of specific recommendations in view of the country's situation and challenges. So this is a summary, and because I skipped all the slides, I wanted to highlight some of the points which come from all those international legal framework for migrant children and also due process rights under the international human rights law. So I will not read everything, but just to highlight the guardians are key procedural safeguards for unaccompanied migrant children. So the committee recommends that children at the firstly need to be identified as children. So the age determination is very key. And also the guardians should be appointed as soon as possible. And all migrant children matter. Not only unaccompanied migrant children, but also the children accompanied by parents. Important role of Child Protection Authority, information on the rights, procedure, decisions, implications, appeal, remedies need to be provided to the children and their representative in a child-sensitive, friendly languages. Free interpretation, translation, free legal aid, legal representation, support by specialized lawyer is the key, and speedy proceedings, and finally training of relevant professionals, including child protection officer, lawyers, consular officers. So this is my last slide. I'd like to add some of my suggestions and recommendations. It's very useful to look into the UN human rights treaties and documents beyond the CRC, because the Human Rights Committee also developed the jurisprudence and general comments, and the Committee on Migrant Workers as well. And also UN special procedures have a lot of very relevant reports. And finally, my suggestion to the practicing lawyers who are participating today. So firstly, we should try to apply the recommendations from the committees in the individual cases, but also advocate in the system and among the professionals, and then advocate for the systematic structural changes and policies. So that's all. Thank you very much.
Thank you, Mikiko, for that comprehensive overview of the international legal frameworks and for guiding us through the different case law and standards. So we'll have some time for questions, but before that, we will now turn to the second presentation, focusing on the EU Pact on Asylum and Migration, which is set to be implemented by member states in July 2026. So our next speaker is Isabela Atanasiu, Legal and Policy Officer in the Asylum Unit of DG Home at the European Commission. Isabela will walk us through the guarantees and novelties introduced by the different legislative texts composing the pact. So thank you, Isabela, for being with us today. The floor is yours. I can see your screen, not in presented to mode yet, but yeah.
I just need to put the slides in the presentation mode. Are you seeing them right now?
Yes, perfect.
Perfect. Hello, everybody. I just wanted to start by saying that I very much appreciate the presentation that was given previously by the colleague. It is how should I put it? I mean, from the point of view of somebody who works in the European bubble, I think that we are very often not so much aware of how many things are available in international law and we can draw upon. And we tend to look only at our legal framework, be it at the European level and the national one. But we tend to disregard the existence of all these useful guidances and case law and the recommendations and all the principles that are out there. So I very much appreciated personally the in-detail overview that was given previously by the presenter. Now, what I am going to do in my presentation is to discuss basically the new procedural safeguards that were introduced in the context of the EU Pact on Migration and Asylum, with legislation that comes into force, as you know, as of next June. I am focusing in particular on legal representation and the procedural safeguards. So I am not going to cover in my presentation the aspects that are specifically related to reception conditions for the unaccompanied children. Now, to start my presentation, I have thought that it is useful to give a little bit of structure to the way of thinking about legal representation and procedural safeguards. And from that perspective, it is useful to look at the main areas and the steps, if you like, the sequencing of the various procedural steps that are relevant in this area. Everything starts with screening and registration, which happens usually right after apprehension or after disembarkation. And for those people who do apply, for those children included who apply for asylum, this is where the initiation of the asylum procedure kicks in. And here we have several steps. I mean, the first important ones being the making, the registration, and the lodging. Very often in some member states, registration and lodging are basically only one step, so they are done together. Then what happens is the examination of the application, where we have important landmarks, if you like. Possible admissibility checks, the personal interview, which is, as we know, the key to the examination of the asylum application, decision-making and notification. And then we go to the stage of the appeal, if relevant. And also, there is also a block that is particularly relevant in the European context, which is about transnational procedures. And here we're talking about the Dublin rules regarding responsibility, who is responsible for the examination of the application of an unaccompanied child, possible relocation cases, legal pathways, which include resettlement and family reunifications for those who have already obtained international protection. And there is a cross-cutting principle, which we have heard of previously, and it is the best interest of the child, which is supposed to be a primary consideration throughout all these procedures. We have also heard that the best interest of the child is more than a simple procedural right. And I think that is an important remark to make in that context. Now, here, what I'm going to give you is just the highlights of the main areas throughout the procedure and in the context of the reception of the children, where we have strengthened the guarantees for the unaccompanied children. In terms of procedure, so now there is a clearly spelled right to receive information from the very beginning, from the moment of making the application, and previously possibly when persons who are likely to be eligible for protection should be guided in the case of children towards applying. The information has to be provided in an age-appropriate manner, in a language that is comprehensive to the children and friendly to the children, and in the presence of a representative. There is the novelty of legal counseling at the administrative stage. I'm going to talk more about it later on. There are, let's say, more safeguards in terms of detention, if you like. Detention of unaccompanied children has not been banned, as many would have hoped for. It was not the right political context, so to say. But there are stronger guarantees in the current legislation regarding the use of detention for the unaccompanied children throughout the procedure. It can only be used if it doesn't affect health, if it is considered to be in their best interest, and where there are no effective alternatives available. So the issue of the effective alternatives is very important to highlight, because member states should not invoke the excuse, if you like, between commas, of not having alternatives, viable alternatives to detention in order to apply detention. There is an obligation to create alternatives to detention, and the true exception is of detention when those are really not feasible or effective. It's not because the member states has not have time or resources to contemplate creating such alternatives. There are tighter rules in terms of representation, or what we call guardianship, and I will give more details later on. In terms of education, now there is a lowering of the maximum deadline for giving access to education to the migrant children from 3 months to 2 months. It is a maximum deadline, so access should be given as soon as possible, so we do not have to wait for 2 months, but that is a maximum deadline. Healthcare should be provided on the same term as for the national children. There is an introduction of new common rules on age assessment, and with the famous so-called multidisciplinary age assessment. I will also talk a little bit more about that later on, but basically just to say that there is the rule of not jumping straight forward to the use of invasive medical examination methods, such as X-rays and so on. The idea is to start with a multidisciplinary age assessment approach, which may include also the views of doctors, but without using invasive methods. There is also an exception of the unaccompanied minors from the application of the border procedure, or accelerated if you like, unless they are posing a security threat. I will also talk about this a little bit more later. And last but not least, there is a rule of prioritizing the cases of families with children if they are put in the border procedure, or of deprioritizing them from the border procedure if there are no suitable conditions for those families with children to be placed in the border procedure. Now, I will refer to basically guardianship and representation, starting from the procedures that I mentioned before. So the first step is screening. In the screening regulation, we have now explicit provisions about the appointment of a representative, or at the very least, where it is not feasible to appoint a temporary or permanent representative already, at the very least, member states should ensure that there is a person trained to safeguard the best interests of the child present at the moment of the screening. Also, we have Article 13.5 in the screening regulation, which provides that this person should not be in charge of more than 30 children at the same time. The representative, if appointed, must have the necessary skills and expertise. Then in terms of tasks, they have to uphold the best interest of the child in the context of the screening procedure, ensure that the child's well-being is being respected or supported, if you like. Then I wanted to make a few notes with respect to the screening regulation step. So first of all, it is irrelevant, as you know, in terms of putting the person afterwards on the right track. What is the track? After screening, the person can be directed to the asylum procedure if the child has expressed an intention to apply. If not, they can be placed in the return procedure if they are irregular and qualify for that. And last but not the least, there is also the possibility of placing the child under the National Child Protection System in cases where there is a possibility to regularize them or where the national legislation protects them, the children, irrespective of their migration status. There are countries in Europe, I can give a few examples. I mean, one is Italy, another one is France. I believe that Spain and Greece are also examples in this sense, but there are certainly more examples where children are protected under the national law, irrespective of whether they arrived irregularly as migrants or not. So this means that for those children, the possibility of the eventual return is not contemplated, at least until they turn 18. In terms of the age assessment, what happens if the screening authorities, the border police, to be more practical, have doubts about the age of a person who declares to be under 18 but does not have evidence to support that declaration, and they also suspect that the person may be over 18? Well, the screening regulation does not contain provisions about age assessment. So that means that if the person has also expressed an intention to apply for asylum, the person must be referred to the asylum authority, and it is the asylum authority who decides if and when to initiate the age assessment procedure. For those persons who do not apply for asylum, the issue is a little bit more in the gray area, if you like, in terms of the framework at the European level. If the person is in the third category that I mentioned above, meaning the national law foresees that they are children, age assessment may still be relevant, because if they claim to be children but they are not believed in that context, then there may be a relevance for carrying out an age assessment, but that is not going to be covered by the asylum rules and the guarantee on age assessment in the asylum procedure regulation. Under the return regulation proposal, to the best of my knowledge, there are not explicit rules about carrying out an age assessment for those who have not been asylum applicants. Then finally, a point about security checks. We also received at the level of the Commission frequently questions about what are the safeguards and guarantees that the child can benefit from in the context of the security clearance that is carried out at the screening stage. There is nothing specific in the screening regulation about how security checks should be carried out for the unaccompanied children, but there is some guidance, if you like, and you will probably be covered, at least in part, by the upcoming Commission guidance on the screening process. Because there is relevant jurisprudence from the European Court of Justice, and there is also national jurisprudence on how to safeguard the rights of children in the context of security checks. Turning to Eurodac, so here, as you know, that we have lowered the age for taking the biometric data from 12 to 6 years old. There is also a new database that will be used in order to register the biometric data. And the intention is to make this database also useful to assist in cases where children, for example, go missing. that could be one of the possible uses of the new database. And there is also in the Eurodac clear reference to upholding the best interest of the child, which must again be a primary consideration. The question that we need to delve more about is how to operationalize it in the context of the Eurodac, because as you know, this is a very quick procedure. I mean, people are being fingerprinted, pictures are being taken, and so on and so on. The question is how to operationalize the best interest of the child in such a context. To be seen. I mean, it comes probably to be of interest in the sense of the presence of the representative and also of carrying it out in a child-respectful manner. So the biometric data of the children must be taken by trained officials in a child-friendly and child-sensitive manner. So this comes up the alley of the best interest of the child, and in full respect of the interest of the child. And last but not least, the reference on the possibility of applying proportionate degree of coercion for the collection of biometric data needs to be taken with a pinch of salt when it comes to applying coercion to children. Now, I'm going to turn to the main blocks of the asylum procedure as such. So here we have the asylum procedure regulation. There are also relevant provisions in terms of guardianship in the reception conditions directive, the new one. And there are also relevant provisions in the asylum, migration, and management regulation. There is the new figure of the temporary representative, which has been introduced. So this is a little bit self-evident. The temporary representative or temporary guardian is to be appointed while procedures are carried out in order to appoint a permanent representative who must be appointed within 15 days from the making of the application. It is clarified that the same person may be a representative in all procedures, so also for the purposes of the MMR, also for reception conditions and so on. There is a maximum ratio of children per representative, which is established at 30 children, and exceptionally in cases of high influx to 50. It is a ratio that has been established through negotiations. Probably somebody is going to ask how was the number of 30 established. We came up with this number through negotiations, but it is obvious that it is just a number and it may mean different things in different institutional settings at the national level, depending on how guardianship is organized and carried out. There are specific requirements now laid down in the legislation regarding qualifications, the training, and the role of the guardian. There is an obligation for the member states to supervise and monitor how they carry out their tasks. There is a right for the child to complain when the representative does not perform his or her tasks adequately. And there is an explicit implication of the representative in the age assessment procedure established by Article 25 of the APR. Now, in terms of additional procedural safeguards that I mentioned before, I mean, there are more rights in terms of the procedure for the children than under the current regulation. The first one is free legal counseling at the administrative stage. Here, I'm going to give you, in the next slide here, a little bit more detail about what is the difference between legal counseling and legal advice and representation. It's a question that we frequently receive. So there is a little bit of confusion about what should the legal counselor do and what should the legal advisor do and the representative. Well, in the asylum procedure regulation, there are articles 16 and 17 which cover, and then a little bit what each of them should do. There is a little bit more context in articles 15, 18, and 19 of the APR. Basically, the legal counselor is doing a little bit of less personalized assistance to the migrant. The legal counselor can work for several applicants at the same time, and he or she offers more general guidance and assistance through the procedure. Whereas the legal advisor is always working one-on-one with the migrant. There is a more in-depth assistance that is given. It's personalized to the case of the individual applicant, and there is also help with preparing the documents for the application, for the appeal, participations in the hearings, and so on and so forth. Basically, under the new framework, at the administrative stage, member states must provide free legal counseling, and there is the right of the applicant to receive legal assistance and representation, but against cost. It's not free. Whereas at the appeal stage, there is a right to receive free legal assistance and representation. Now I'm coming back to the right to be heard, which we have heard previously again, how important it is. So it is a right to be heard throughout every step of the procedure, not only in the appeal stage. And it's important to underline that it is a right. It's not an obligation for the applicant. So the child can always refuse to be heard if he or she or the representative do not consider it is suitable for their best interest at that moment. In terms of the age assessment, like I mentioned, we introduced for the first time common rules at the European level. Before, there were no common rules on the age assessment and carrying it out. We make the first step of the multidisciplinary method of assessment compulsory. And there is a deadline of 30 days for concluding the age assessment because it is a vulnerability assessment. And it is covered by the deadline foreseen by Article 21 in the RCD, if I remember correctly. Then, as a matter of principle, unaccompanied children are exempted from the border procedure, both from the optional border procedure and from the mandatory one, unless they constitute a public security concern. However, this exemption has a little bit of qualifications, if you like, in the cases of those persons declaring to be under the age of 18 and where the authorities do not have evidence and they have doubts, and where an age assessment will be carried out. What happens to these people? Well, if they satisfy otherwise the conditions for being placed in mandatory border procedure, those are three kinds of circumstances, and I think you probably have them present. So it's having presented misleading information, being a security threat, and being from a country which has very low recognition rate. So if they satisfy one of these three conditions and there are doubts about the age, the person will be temporarily placed in the border procedure while carrying out the age assessment, which, as I said before, cannot last for more than 30 days. While being in the border procedure for this temporary period, the person will benefit from all the other guarantees available to children, meaning they must be placed in a reception facility that is suitable for unaccompanied children. There must be security provided. They have to have a guardian appointed practically immediately and have regular access to the guardian and be assisted throughout the age assessment procedure. If at the end of the age assessment procedure, the conclusion is that the person is a child, the person must be immediately taken out from the border procedure and put into the normal border procedure. If, however, the conclusion is negative, the person remains in the border procedure and the application will be processed there. The regulation does not speak about the possibility to appeal separately the age assessment conclusion. That means that there is a possibility for member states, if they have this into their national legislation, to have a separate appeal. The APR does not preclude that. It can be considered acceptable. If, however, national law does not foresee for a separate appeal, there must be a possibility to appeal together with the appeal against an eventual negative decision. So that must be satisfied at the very least. Families with children can be put in the border procedure, but their cases must be prioritized. And if the conditions are not, they must be met there in the border procedure. They must be taken out and put in the normal procedure. For detention, I already mentioned the reinforcement of the last resort nature. And there is also mention to be made about the best interest of the child and family unity. Yeah? This has implication in cases of detention and the restrictions of freedom of movement in the context of the border procedure. So basically to say, I mean, there are very different constellations. For example, one may think there is a family where only one adult member of the family possibly must be put in the border procedure, but the rest of the family and the children do not qualify for being placed themselves in the border procedure. In that case, what do we do to preserve family unity? There will be more guidance and more detailed guidance on this coming from our forthcoming guidance on the asylum procedures, border procedure. But just to say that we are giving guidance in the sense of preserving family unity in such contexts, not by placing the whole family together in the border procedure, but by allowing regular contact. There is also an explicit obligation to set up independent monitoring of compliance with fundamental rights in the context of the screening process and the border procedure. This I have already covered. We can go to the transnational procedures. Here, basically, what I wanted to say is that the rules on establishing the responsibility for the examination of the application of the unaccompanied minor have changed. As many of you know, currently the idea was that if the person has engaged in subsequent movements in different member states and applies in several member states, the member state who would be ultimately considered responsible is the one where the child is present, if this is in their best interest. Well, now the rules have changed on that aspect. So basically, if there is no family reunification ground, by default, the responsible member state is the one where the first application was made. So basically the country of first entry, if you like. There is also a more clear spelling out of the definition of family members, and there are rules on relocations where we have an importance of carrying out the best interest of the child assessment in order to determine if the relocation to a specific another member state is indeed in their best interest or not. And we have a particularly important role of the representative and legal counselor to play in the context of such a procedure. This is my last slide. I wanted to say that we are preparing guidance to come on the application of the border procedures, on the reception conditions, on detention and alternatives to detention, and on the screening procedure. The first one that will come up very soon in a few weeks is the screening one. We are working on all the other ones. We are quite advanced, so they are probably going to come out hopefully this winter. FRA is working on updating the handbook on the guardianship for children deprived of parental care. It's very good and handy reference document for the guardians. And then the European Asylum Agency is preparing updates of the practical guide on age assessment and the guidance on the best interest of the child. And by mid-2026, there is a series of practical tools that are being finalized as well. You see here some links. They look broken, but they are actually functional. So when you get the slides, you can click on them and you can basically access the reference to the document. And with this, I am going to conclude my presentation and thank you for listening to me.
Thank you very much, Isabela. This is extremely relevant for a practitioner within the EU working with the directly with children and also for the resources. The EU Pact on Migration and Asylum raised concerns on how member states will implement these procedural standards, even if they also have the possibility to adopt higher standards. I imagine that many of you have questions or comments, so now I will open the floor to discussion. So if you'd like to contribute, please raise your hand and briefly introduce yourself and then share your question, comment. If you can also type it in the chat so I can see Juliette. Go first if you want to.
Thanks a lot, Laura, and thank you both for the presentations. I'm Juliette Remontier-Drez. I'm Associate Legal Advisor on Libya at the International Commission of Jurists. And I have a question for you, Isabela. Thank you. It was really useful because it's such a difficult pact that it's difficult to unravel. So it was really good to have this overview. I'm not a migration lawyer, so some things kind of elude me. I don't really understand how detention can be in the best interest of a child, like in practical terms, what cases can mean that it would be in their best interest. Thanks a lot.
Should I take the question immediately or should I wait for more?
Maybe we can add one more from Agnieszka, and then you can.
Hi, thank you very much. I'm Agnieszka Matejczuk. I'm from Poland. I'm an immigration lawyer. I work in Ombudsman for Children office. And I have a question regarding age assessment because we recently received return regulation, the regulation for common return system. And we received the Commission proposal together with compromise proposal. That is from the negotiation between the countries. And unfortunately, we noticed that in the compromise proposal of this regulation, the part when it says about multidisciplinary assessment is actually annulled. They suggest to not include that part. It's Article 19 of this regulation, and so in the Commission proposal it said that it has to be done in the multidisciplinary way, and in this compromise proposal this part is not present anymore. So I wanted to ask you if you have maybe some knowledge about it, what we can expect to actually be in the end outcome. Thank you.
Yeah, I guess maybe Isabela, do you want to answer?
Yes. The first question about when can detention be in the best interest of the child? I must confess that I personally have difficulties to see a credible such case myself. But the usual example that is being given by practitioners at the level of the member state is a case where let's say there are security threats, but not the child being himself or herself a security threat, but there are securities about the safety of the child. Debatable. If alternatives cannot be used, I quite honestly, it's a difficult question, and I do not have, in full honesty, any example that I can give of a case of a detention, full right detention, where I would personally consider it to be in the best interest of the child. About the return regulation and the compromise text and taking out reference to the multidisciplinary age assessment. I'm not following that very closely, so I'm learning from you that the compromise text prepared by the Council is taking out the reference to the age assessment. It's interesting to learn about this. But what I can tell you is that the compromise text is not the final text. So, I mean, you asked what is to be expected. We don't know. I mean, let's see what the Parliament asks. There is still a long process of negotiation ahead. So I am hopeful that the provisions on the age assessment will be brought back. And I can know for sure already, without having to check with colleagues, is that the Commission will defend bringing it back. So I think that is the case.
Thank you very much.
Okay, so we have two additional questions in the chat addressed to you, Isabela. So one is, will the upcoming guidances be available to the wide public or only the member state authorities?
Yes,
And
so that is answered.
Okay, that's great to know. And then the second one is, if an age assessment is deemed pertinent during the screening procedure, but Article 25 does not apply since it's not yet the Asylum Procedure Directive area of application, what are the safeguards protecting the minor during the procedure?
Not sure I understand very well. I have to read it again. But I mean, you're asking basically about what happens at present. I do not see the chat, so I don't see the question in writing.
Sorry, I can read it again, or maybe the person
It doesn't
asked
matter.
can-
I mean, correct me if I'm wrong. I mean, the question is what happens at present under the current directive where we do not have
the screening regulation, under the screening
under the screening regulation, what happens? I mean, I try to explain in my presentation, but I mean, the thing is, if the person applies also, I mean, expresses an intention, manifests the intention to apply for asylum. This is all what it takes. At the moment when they say, I would like to apply for protection, they are asylum applicants. So at this moment, the border police has to refer the person to the determining authority. We call it this way. It's basically the asylum authority. And they are going to refer the person to the asylum authority and say, look, we have this person who wants to apply, and we have doubts that this person is a minor of age. This person may be an adult. The declaration is that they are minor of age, but they may be an adult. At this moment, the asylum authority kicks in the age assessment procedure. But it is the asylum authority, it's not the border police who kicks the process, who starts the process.
Thank you. So I can see another hand raised from Erika. Erika, if you want to speak, or maybe it's not something on purpose. Or maybe, okay, let's first start with Carolina, and if you want to jump in after Carolina, you can go ahead, Erika.
Hi everyone, maybe we see Erika now and she's joining. Okay, otherwise I'll go ahead. Thanks a lot for the presentations, both Mikiko and Isabela. It was really good to listen to it. So I just also wanted to come back to the age assessment question, Isabela, and just to clarify a bit. So if I understood well, so the unaccompanied minors are in principle exempted from border procedures, but then when there is a doubt about their age and age assessment is pending, they will actually be placed in a border procedure and they will be detained. So there won't be actually the benefit of the doubt, which is kind of the main principle linked to age assessment. And also, as Mikiko raised it before, it was also said many times by the UN Committee on the Rights of the Child, it won't really be observed, if that's the understanding I have. And perhaps also if you could say more whether you think there will be some more specific guidance on this to member states to actually clarify this question. Thank you.
Yes, it's a very good question. Thank you. First, to start, I mean, it's not only about the unaccompanied children, but in general. Border procedure does not necessarily have to involve detention. So it's not foreseen by the asylum procedure regulation that when you apply, you must put people in detention. If there are solutions of restricting freedom of movement or solutions which can be worked about to provide alternatives, that would be perfectly fine under the APR, and we are actually even recommending them in the context of the forthcoming guidance. Having said that, in realistic terms, yes, I understand that this is not going to be a reality always. Indeed, there is a little bit of a problem. I mean, basically in our guidance, what we will recommend is using facilities whereby the the children can nevertheless have a certain degree of freedom. It is a difficult dilemma from a practical point of view, although in theory we are always recommending the use of alternatives. Let us see how this unfolds in practice. And also, one of the things that is very important to underline is that in such circumstances, like I said, I mean, all the reception conditions should be respected for the children. So that is one thing that is for sure. So at the very least, having a safe zone in a multi-purpose center. So you see what I mean. And also that they have to enjoy the things that are typical for the children while they are there. So have regular contact with the guardian, be allowed to be outside, be allowed to play, all these kind of things. Beyond that, like I said, to be seen how it unfolds in practice, and let us not forget that it should take maximum 30 days. So it should be as short as possible.
Okay, so we have another question regarding the assessment from Erika, but maybe you already said some of it already, but she asked if you can further develop on the compulsory age assessment procedures, compatibility with the best interests of the child principle.
Yes, I mean, I think that in this context, the idea is that in a certain way, if you like, the very fact that we have an age assessment possibility under determined rules, and we have a methodology which is supposed not to be invasive at the very beginning, and at least until it becomes unavoidable, if it's not conclusive with the multidisciplinary age assessment, only then you can go to the medically invasive methods and so on. I mean, all these guarantees are already a step into ensuring that the procedure is in the best interest of the person. Because ultimately, if there are doubts, it's better to have a procedure that goes on which is respectful of the child, rather than go directly to decide this person is not a child, which is what we were risking doing otherwise. Having said that, in the context of this age assessment procedure, there is room for making it even more in the best interest of the child by flanking the person with the guardian, by having appropriate counseling and all the rest. So basically respecting all the kind of support that the person needs throughout such a process in order to make it child-friendly. Yes, I think this is all that can be said about the procedure as such. I mean, there is always a discussion about whether it is, you can say, to put it like this, I mean, can you say that it's not in the best interest of the child and skip the age assessment procedure? No, you cannot. The age assessment procedure is a prerogative of the state, okay? If the state has doubts, they have the right to carry out the age assessment procedure. That is a thing that shouldn't be even on the table. But they have a right to carry it, but there must be the safeguards for the person who is involved, okay? Let's put it this way.
Yeah, that's the... Okay, so now we have another question in the chat from Mais, but I can also see that you are raising your hand, so maybe you want to say it out loud, or...
No, thank you. I think my question is clear. If I understood well, there will be this change. For me, it's quite an important change on the Dublin regulation that no longer the place where the child is present would determine the state who is responsible. And so, according to me, this will create a lot of sending around children, unaccompanied children, in between European countries. So my question is, where is the best interest of the child? Thank you.
Yeah, well, I have no reasonable answer to give you on this account. I mean, the only thing that I can tell you is this, that on this aspect, there have been hard negotiations before the adoption of the legal instrument in question. This is the outcome of what was negotiated.
Thank you. Is there any other question or comments or more? Yes, Odin, go ahead.
Yes, thank you very much, Lauren. On the last issue, if the child, for example, has like an uncle in let's say Germany, and he asks for asylum in France, what will be the investigation in Germany in order to assess whether it's in the best interest of the child to go to the uncle in Germany? Is there any thought about that? And if not, is there going to be any specific recommendations by you? Can we expect that?
It is one of the things that we can address in the context of one of our guidances. I cannot tell you exactly which of them now, but it is an aspect that can be addressed at least very briefly, if not in a lot of detail. But one can imagine that if, let's say, you initiate a family tracing in the context of Dublin and you come across the fact that there is indeed a relative who in principle qualifies, right? So there are conditions for qualifying. I mean, they must be regular themselves and so on. Now, this does not necessarily mean that this is indeed in the best interest of the child. One can imagine situations of abuse, of family conflict, that the person may not be suitable because although regular, they might be investigated for who knows what. Now, all these things in principle should be taken into account before deciding whether the person should be reunited with that member or not. It's not explicitly laid down in the regulation, but it goes without saying that this kind of check must be made, and maybe our guidance should go into that direction. I don't know, and I do not think that we can promise a specific guidance on the application of the AMMR procedures for the unaccompanied children, but it's one thing that can come somewhere across. It's a point I will pass to my colleagues who work on this. And ultimately, it is also the role of the, because even if you are only in Dublin, you still have to have at least a temporary, if not a permanent guardian appointed while going through the procedure. And this representative, temporary or permanent as they may be, must do this kind of or ask for such checks to be done. So it is part of their role. They have to ask for the authorities to make such a check. I also have to say that I must leave you in about 3 minutes, so I really apologize, but I have an upcoming meeting.
Yeah, thank you very much. We had some more questions in the chat. I'm just reading through. So I would, someone would like to know to what extent child's perspective is taken into account. Is there any provision regarding this? How do you make sure the child is seen as a right order? So maybe it's even, yeah, I'm not sure if this question is relevant. It's specifically focused for EU law. Then yeah, I guess for the pact. But yeah, I guess I can read the second one or so. I would like to ask how the independence of the guardianship system will be ensured within the new system. In Greece, for example, it is the state that funds organizations that provide guardianship services, which raises concern as to their independence. So if you have like 2 minutes to give in your thoughts regarding this, Isabela, after you leave, but no,
Yes.
you have to.
No, I can address this one if you like. I mean, I'm not going to comment on the first question because I think the whole purpose of the presentation is to explain to you that there are rights. So I think that's the gist of the matter. On the second one, about independence. The issue of whether the guardian should be or not independent is not explicitly regulated in our law, but it has always been part of our recommendations. If you like, even if you think about the 2017 communication on the protection of children in migration, we emphasized that there must be a certain degree of independence to the representatives especially for avoiding cases of conflict of interest. So, for example, there can be cases where the director of the reception facility where they are being accommodated is also exerting the role of representative, and there you have a conflict of interest. So we have always given counsel to the member states to avoid these kind of situations. Having said that, the organization of guardianship at the national level is something that is for the member states to decide. We're not going into this kind of level of regulating. There are countries who prefer to have independent bodies. It's the case of the Netherlands. There are countries which rely on NGOs to perform this kind of function. There are countries that have voluntary citizens who are doing guardianship. There is diversity, and the diversity is, at least from our perspective, welcome. We have no problems with that, as long as the persons can deliver the tasks and look after the best interest of the child, like we said, and the well-being of the child in a suitable manner. So there should be ultimately no conflicts of interest, and the person must satisfy also the requirements of the new regulation. So in terms of qualifications, in terms of training, there is a lot to be said about this, because think about it. I mean, countries who have voluntary guardians may have, under the new rules, a little bit of a difficulty in prolonging the mandate of those who are just simple citizens and do not have professional qualifications. So for that one, we will have to find reasonable ways of dealing with it and allowing for voluntary guardianship to survive the new tsunami of the Pact on Asylum and Migration, but also with reasonable solutions. So there are ways of conceiving how to give training to people and to acquire the qualifications. So this is one way of dealing with it.
Thank you very much, Isabela. Yeah, many questions were directed to you, and but don't hesitate, Mikiko, if you have any final reflection before we close this webinar, because yeah, we are at the end of the time that we gave. I just want maybe to add that yes.
Yes, no, it's just that I wanted to say I apologize, but I have to leave you.
Yeah, sure. Thank you for joining us. Thank you for the presentation.
You're very welcome.
Okay, so yeah, I would like just to add that as part of this project, we are working on drafting a resource, gathering international frameworks and on the right of the child to be heard and participate in legal proceedings, and gathering good practices. We also focus on the guardianship, so it's something that we will share with you on when it's completed. But yeah, I will also share with you the slides after this webinar. So thank you all for joining. I don't know if there's any final remarks, but otherwise we'll have to close it now. Thank you all, and yeah, we keep in touch for this important work that you will be doing. Thank you. Have a nice day. Bye.
Thank you.
Bye.